Well, good afternoon, everyone, and welcome to this discussion on domestic and family violence community lawyering. I'd like to start, please, by acknowledging the traditional owners of the land upon which we meet and pay my respects to the elders past, present and emerging. My name is Robert Reid and I coordinate the Brisbane component of Minter Ellison's Community Investment and Pro Bono program. Many of you will know Minter Ellison as a national commercial law firm dealing in most areas of commercial law, which is great, and I'm lucky enough to have that role full-time of coordinating all of our work in the community. We're delighted to host this event this afternoon for a number of important reasons. Firstly, we want to support and acknowledge the event partners, Community Legal Centres Queensland and the UQ Pro Bono Centre, which is within the TC Byrne School of Law. So Community Legal Centres Queensland is a statewide peak body for CLCs, which provides support and advocacy for 33 independent community-led CLCs operating across Queensland. And the UQ Pro Bono Centre partners closely with CLCs to formalise the involvement of law students in pro bono and public interest legal work. And there's apparently more than 500 law students at UQ keen to do pro bono work, which is awesome. Second important reason that we are delighted to host this event is that as part of our community investment and pro bono program, we've been addressing this issue of domestic and family violence as an important part of the program for over 15 years now. And our activities in this space involve all of our staff, whether they're legal staff or otherwise. For example, we regularly print the much in demand separation booklets for Women's Legal Service. We have a long-standing partnership with Australia's CEO Challenge, who some of you may have heard of. They deliver workplace training around domestic violence and how it affects staff, how to recognise and respond to it. We provide that organisation with office space, admin assistance, board representation, event hosting, and what I'm most excited about is we worked with Australia's CEO Challenge to develop the Darkness to Daylight Challenge run, which this year in its fourth year saw over 2,000 people out at South Bank running together, walking together, shouting together to cover a distance of 110 kilometres overnight. And that distance is 1 kilometre for every death caused by domestic and family violence in Australia in 1 year. So every kilometre covered was symbolic, and it was great to see so many people involved. But what we can do here from a lawyering perspective is limited for a number of reasons. We do stuff, for example, provide organisational pro bono assistance to organisations like Australia's CEO Challenge, and also assisting people experiencing domestic and family violence directly through our involvement in things like Law Rights Homeless Persons Legal Clinic. But it is limited. So by hosting this event, we hope that we can play some part in acknowledging and supporting those of you who are on the ground dealing with these issues on a day-to-day basis, and also informing us about how we can do our bit. Probably the most important reason that we are delighted to host this event is that over the years we have become very aware of, and I would say emotionally connected to, this issue. The more you hear about it, the more you know about it, the more you know that it impacts so many people around you, and you may not have noticed that before you started looking at the issue. As I said, we got involved over 15 years ago, and at that time we did it because we were looking for an issue that generally nobody was really talking about. So logically we wanted to make a difference, but as I said, the emotional attachment to the issue has sort of overcome that. We're so pleased in a sense that now people are talking about it, and they're talking about it in the sense of wanting to find solutions and do something about it and do things better. So we're always keen to do whatever we can to facilitate discussions of that kind. That's why we're so pleased to have you here at this event. And in fact, I understand it's attracted interest from as far away as Karratha on the Western Australian coastline near Port Hedland, which is why we're recording the discussion. So I'm personally looking forward to the session. I need to remind you, slight segue, while I do remember, to sign your sheet there for the CPD. points, but that's not why I'm looking forward to the session. I am looking forward to hearing discussions of the kind I mentioned about what we can do in the lawyering space to make a difference around this issue, to hear from our two guest speakers, and I think it's going to be a fantastic discussion, so very proud to be hosting this event. So firstly, to introduce herself and then the panel speakers, could I please invite Heather Douglas to commence proceedings? Thank you.
My name is Heather Douglas and I'm a Professor of Law at the University of Queensland Law School, and most of my research to date has been in the area of domestic and family violence, and I'm really looking forward to the conversation for that reason. So, over to our guests. First of all, I want to introduce Louise Skidmore, who will be very familiar to many of you in the room. She's the Principal Solicitor of the Generalist Community Legal Service, Pine Rivers, and that's a role she's had since 2016. Among many other things, the Pine Rivers Community Legal Service provides the Domestic Violence Duty Lawyer Service and the Child Protection Duty Lawyer Service at the Pine Rivers Magistrates Court. Louise has had a long association, like so many of you, with community legal centres. She was a solicitor at the same service from 2010 to 2016, and similarly for many of you, she was a volunteer at that service before that. She's had over 20 years of experience as a solicitor. So can we please welcome Louise? And also on my left, the Honourable Judge Eugene Hyman, who'll also be known to many of you who've been working in domestic and family violence as well. He's very well known to me. I receive an email nearly every day from Eugene, as I've been working on the National Domestic and Family Violence Bench Book, and I don't think I could have done it without you, so thanks for that. In 2008, Judge Hyman received the United Nations Public Service Award, which is perhaps the most prestigious international recognition of excellence in public service. The judge was the first American to receive the award. He helped initiate the Juvenile Delinquency Domestic and Family Violence Court, which was the very first of its kind in the United States. And he was honoured in the United Nations Award for the category of, a very important category, improving transparency, accountability and responsiveness in the public service. Judge Hyman has worked across the board in relation to the response to domestic and family violence. He's been a police officer, a trial lawyer, as well as a judge on the California State Superior Court for Santa Clara County for 20 years, where he served across the court in criminal, family, juvenile and probate divisions. Can we please welcome Judge Hyman? We're going to break this up into two parts, but perhaps we can start with you, Louise. If you could perhaps paint us a picture for us in relation to how a generalist legal service comes across domestic and family violence and how you respond.
Sure. Well, at the Pine Rivers Community Legal Service, we're on the north side of Brisbane and we're a generalist legal service. Obviously, the area of domestic and family violence is a specialist area of law. And it often involves family law, criminal law, credit and debt, Centrelink, tenancy, substance abuse, mental health. And how do we respond as a generalist community legal service without the expert knowledge that other services may have in the community? We're a small team. There's 3 of us, solicitors and 1 admin person, and then we have a number of volunteers who volunteer their service. Generally, we give advice by appointment, but we've discovered that the best way, through our experience, to actually respond to people coming into our offices for help with regard to domestic violence is to be available. And often it's people who have decided to come in that today's the day they're going to make a decision and today's the day they're going to take action, and if we can't be there and available and respond to them straight away, that opportunity is lost. So we've had to try and adapt our practice to be able to be available. I was looking at some stats and I see that 23% of the people in the last year that we see at our community legal service have ticked the box on our intake form that says that they are experiencing domestic violence. That's surprised me because I wasn't aware of how many people are actually ticking that box, and that's even before they, that's only those people that actually tick that box. There's a lot of people who come in and it's only during the course of a consultation that it becomes apparent that there is domestic violence. So there's a lot that's probably not up to scratch in terms of our stats, but 23% is a really significant level for us. So most of the time I thought I would share with you typical scenarios, and you probably all have similar circumstances that other generalist CLCs might experience, people coming through the door in different ways. Mostly people come in either in crisis, walking through the door, or they come phone and make an appointment to see us, or they're referred to us through the duty lawyer service. So people who come in through the door are those people who are ready to disclose and declare that they are experiencing domestic violence. We see both perpetrators and aggrieveds. So whoever comes in the door first, we help. If a perpetrator is conflicted out, obviously we have to refer them on, because as a duty lawyer service we are there as a duty lawyer service for aggrieved. So sometimes we don't end up seeing the alleged perpetrators if we've already seen the aggrieved in the duty lawyer service. So really, typical scenario may be that the magistrate at a duty lawyer service at the Pine Rivers Magistrates Court might refer us a person who has come into the court and not even put their name on the list to see the duty lawyer, and then the matter stood down and is referred to us for some advice, and from there we then help at the duty lawyer service, and then subsequent follow-up appointments are made either at legal aid or at our own offices, and we have to make sure that we are available to be able to help people with that. We're not trained in trauma-informed consultations. Our job is lawyers, and I think that's what we struggle with sometimes, is what role can we really play in the community legal service setting. If we were to give really just legal advice, we might talk for 5 minutes and say these are the narrow boundaries of what you can and can't do, but we all know in the community setting that that's not often the case. People come with usually family law related issues, and their first question is about, if I separate, what will happen financially to me, what is it going to look like? Or they'll come in and say, I'm worried about the children and what will that look like? Sometimes not discussing domestic violence at all, and only then when we start discussing about finances or children or situations that people then start discussing about what they've been experiencing. We often are the first point of contact for people. I think some of the time that people have experienced physical violence often have had access to other services, but people experiencing financial or emotional abuse seem to come straight to the community legal service where they are, and that's the first time that they've talked to anybody. So our frontline staff actually are trained to not send anybody away if they walk in the door, to make somebody feel comfortable, just practically. There's a small team, we just say, have a seat. One of our solicitors will be available as soon as we can, and then we just try and, as soon as somebody becomes available, make the time to see them. Because we do know that if they go away unhelped when they're ready for help, that will be the worst thing that we can do. So it does place enormous strain on the resources of our service. So we always try and help. And recently had somebody, for example, coming in with 2 small children and had been housed in temporary housing, moving from hotel to hotel and wanting to go back home, and just walked in the door to get some advice. And we had to do exactly that. Our volunteer reception babysat. I helped babysitting. Client went in with one of our solicitors who had just finished a client and had an admin time, and sat down and discussed the matter with the client and prepared an application for protection order with an ousting application, and then was satisfied that the other support around the person was sufficient to be able to narrow our focus to the application itself. So that's the kind of experience that we have: referrals, walk-ins, people phoning and making an appointments for family law, and then discovering that there is this DV component. We are part of a bigger team. We're part of a neighbourhood centre, which is really invaluable. So we do have the ability to offer specialist domestic violence counselling, and we do have that in a separate building from where we are, because we're situated separately. But I think the main concern for us as a legal team is how can we respond, make ourselves available to be able to meet those needs in a legal setting, and then refer on either within our own organisation or elsewhere in the community. And really that's our experience is, are we trained sufficiently? Do we have enough resources to be able to do that? Usually not. And where else can we send people if we can't help them? But we do go out of our way to make sure that we can, because of the growing numbers of people that come to our door.
That's great, yeah. So there's probably lots of questions from people, but we might have a time at the end for some questions. Perhaps, Eugene, can I go to you, and can you perhaps talk to some of your experiences on the bench?
Yeah, sure. This is a United States perspective. I hope that some of the concerns that I express are not your concerns, but they might be. There might be some consistencies with respect to throughout the world. I think family law is the most difficult assignment for a judge. I think it's the most difficult assignment for a lawyer. You're trying to convince the court to do something in the area of, let's say, child custody, visitation, and access with insufficient information. You know, judges have to be very careful in terms of making suggestions, in terms of, I'd like to see this would be helpful, because you might be perceived by a party as trying to be helpful towards someone else. 75% of the parties appearing in California courts, and probably throughout the United States, are self-represented. And as a result, our canons of ethics do allow us to give a little bit more direction when both sides are unrepresented. A huge problem with respect to every actor that intersects with domestic violence is implicit bias. In my view, it's huge. And the biggest way it presents itself is the number of people that believe that if the domestic violence was so horrible, she'd leave. This is 50 years later, at least 50 years later, that it's been studied, domestic violence, we've been talking about it, and we're still talking about why does she stay? We're still talking about women can be violent too. Give me a break. You know, the research is clear that the number of women that are committing domestic violence is 10 to 15% of the population, and most of that is same sex. Then there's a terrible lack of education on the part of everyone with respect to domestic violence, what it looks like, how it appears in the different divisions of the court, and it's in several divisions, and families are usually in several divisions, and the divisions don't talk, the lawyers don't talk, no one's talking, and as a result, a disservice is occurring. And a huge thing that people are not comfortable talking about is sexual assault, as well as non-fatal strangulation. And we need to be talking about these things not just for purposes of prosecution, but for purposes of child custody. Because a person who's sexually assaulting their partner or non-fatally strangling their partner shouldn't be having unsupervised access with respect to children. Expert witnesses frequently do not know what goes on in other divisions of the court. So a child evaluator might understand what a conviction for certain crimes are, but probably does not understand probation conditions, and probably doesn't understand how failure to follow probation conditions might impact in terms of whether they should be getting visitation or not. Then there's also the co-occurring problems of substance abuse, mental health, and other kinds of issues. I recommend that if at all possible you avoid the family court. The family court does not have sufficient resources, does not have sufficient time, and depending upon the person that you're appearing in front of, and I appreciate that you have a separate system in Australia. In the United States, frequently people that wind up doing family law are new judges or judges that are being punished because they haven't been taking care of business in some other division of the court. And so there are miscasts that are sent, sometimes, not always. I mean, sometimes you have people volunteer. In all candor, I didn't volunteer. I went, I did the best I could, and I think it was great for doing juvenile justice down the road. The other thing is that social science is not respected with respect to judicial decision-making. I think that's a huge mistake. I think there needs to be more appeals. I think I used to, when I was in practice, if I thought a judge was wrong, I appealed even if I wasn't paid for it, because it just incensed me so much in terms of potential injustice occurring. And even if you don't reverse them, you get a begrudging respect, has been my experience, both as a practitioner and as a judge. And I always knew when someone was appealing me, because the court reporter told me they were ordering a transcript. And then you begin to sweat a little bit and go, gee, I wonder what I did wrong. And 99% of the time, he did nothing wrong. But if someone thinks that you did, then they obviously have the right to do what they think is important. You got to brief the issues. You can't assume that your trier of fact understands the legal issues. You have to assume that they don't, and then you brief. The first time you brief an issue, it takes a lot of time. Thereafter, you're changing the fact patterns, and you're arguing the facts to the law that is pretty consistent usually. So I think there ought to be more briefing, and I think there needs to be, as I said, a lot more training. Also, risk assessment must be reviewed every time a batterer comes in contact with an actor, because risk is not static. And so, they will say, well, gee, Judge, so-and-so found, the defendant, the client, whatever, to be okay. Well, what's going on today? Because if someone is saying something something that's alarming, then you need to do something differently than has been done, and that isn't something that occurs on a regular basis. And that's how accidents happen, and that's how people get hurt.
Mm-hmm. Louise, you alluded to this before, but can you give us some indication of what you think would be a sort of holistic practice in response to domestic and family violence from your perspective, working in the legal centre?
Certainly to be able to be well connected with other support organisations, and at the Pine Rivers Legal Service, because we're part of an organisation called Encircle, which has two neighbourhood centres, young parents program. In fact, I've written a list there. Homestay, family support, emergency relief, literacy support, Centrelink comes on site, multicultural groups, mental health support, specialist family violence counsellors. We provide food, clothing, personal hygiene packages, phones, access to phones, computers, go-karts, furniture, moving help. So it's very much, each of these services have their own intake, and they all have a unified response to domestic violence. And if we can refer it within the organisation, the matter, then we will, so that we can actually immediately access whatever support is needed. Our specialist domestic violence counsellors run groups and individual family and counselling for children as well. So it pretty much covers as much as we can, but we are a small organisation, so we can only see so many people. But I think being able to, while somebody's waiting in reception to see the legal service, to be able to speak to the specialist domestic violence counsellor, or see what kind of social support, so as to avoid social isolation, to get people to be connected with the other groups. We have a multicultural group. So it's trying to address any needs, as well as obviously the priority of the safety planning and things.
So you've got a big advantage in a sense, because you're part of a neighbourhood centre,
yes,
and Encircle and so on.
Yes.
But obviously you mentioned that you have to refer externally as well from time to time. So how do you maintain those broader networks of relationships? Do you have practical suggestions about how that's best done, or how you do it?
Well, I think we really had to up our level of knowledge about who's in the community when we started doing the domestic and family violence duty lawyer service, because it became even more important for us to know who else to refer to and what services there were. Mm-hmm. So we do have CARDA, which is the Centre Against Domestic Abuse in our area, men's information and support groups. So we maintain an up-to-date list of who is out there in the community and who's able to help in expert areas where we're not able to support people.
Okay. And how about you, Eugene? We've just introduced in Queensland a whole range of information sharing protocols. We're experimenting with specialist courts and so on. It's a bit of a different issue perhaps for the judicial or judiciary to get involved with connecting with services and so on. But how do you deal with that issue of court integration so that the services are all working together with the court as part of that essentially service provision?
Trying to think how to respond in a civil way. It's a problem because everyone wants to be a silo, and everyone wants to say it's not my problem, and everyone's concerned about, get this, mission creep. So if I tell the police, which I have when I've lectured to them, that they need to realize that their reports are used in family law, and that if they don't want to get excited because they've been to this family several times, get excited for the sake of the children. Most people can be motivated by children, even if they're not motivated about safety for the victim. I lecture to the doctors. Do you realize that your medical reports are critical in terms of potentially, with respect to outcomes of family court matters? If you would just spend a little additional time to say how when Johnny is visiting his father, he doesn't take his asthma meds. When he comes back to mom, he wets the bed. Or when he goes to school, he acts out. He causes problems the next day after a midweek visit. That kind of stuff is critical. And that's the kind of stuff that judges aren't getting. Now, you would think that in those cases, those few cases where there are lawyers, they would be doing these things. They're not. I once asked a prosecutor, why aren't you going to the family court looking at the file? Because there's some real gems there. Because sometimes, because they're self-represented, they'll respond to a protection order or a restraining order, and he'll respond to the moving parties, and he'll say, she says she indicated that I hit her 5 times. I only hit her once. Well, okay. You now can prove your case beyond a reasonable doubt, but you need to get there to get the report to be able to use it. I really don't have the time. Well, I'm not saying you have to go down to family court. Send a paralegal, send a law student, send someone. Why aren't you going there? Well, because we don't have the time. And this goes on because it's permitted. Judges aren't holding lawyers accountable. Lawyers aren't holding judges accountable. No one's holding anyone accountable because everyone wants to get along. And please, I'm not trying to suggest that camaraderie isn't important. It is, especially in a place as civil as Australia. But it's critical for the sake of children and for the sake of victims that there be a little bit of pushing in terms of making sure that information gets before the trier of fact. And remember, in the United States, we do jury trials whenever humanly possible because they don't trust judges. Here, even when you have the possibility of a jury trial, it's a court trial usually. So judges can only make decisions based upon information. So at least give them the assistance of getting the information and hoping that they get a better outcome.
Let's talk a little bit about training as well. And Louise, you talked to this before, that you don't have trauma-informed training necessarily. Should we, and judges as well, should we be working towards better approaches to that? Should lawyers be better equipped? Should we be thinking around these issues a bit more?
Certainly in the Community Legal Centre, and absolutely essential. We look out for any training that we find. Recently there was one run by Tenancy on domestic violence and tenancy, and so we enroll ourselves in every possible opportunity to learn more. The difficulty that we find is that we're often asked to give advice and do community legal education on topics as well. Recently have had a request from our local domestic violence agency about this information sharing guidelines. So I'm being asked to talk about that in a month, and I've obviously said no because I'm still reading about this. I'm sure. Does everybody else know all about it? Because I don't. Information sharing guidelines, which is changing scenario. So we're being asked to share information about things that we're still learning. So we're looking to be taught ourselves, and obviously have to limit on both levels what we can provide, what information to the public that we can provide. And we certainly do host respectful relationship seminars. We've connected with university to do joint presentations on that level. So on the one level we are the trainers and giving information and advice, and on the other level trying to absorb as much information as rapidly as possible, knowledgeable and expert, so that we can actually be in a position to do that. So anytime any changes come up, there is nobody, knocking on our door and saying, do you know this is happening and are you aware of this? It's up to us to make sure that we look out for whatever training opportunities we can grab onto and educate ourselves and make sure that we're up to date to be as best as we can to be able to help people.
So is there a bit of a gap in affordable training on kind of trauma-informed
there's no budget
lawyering?
There's very little budget in
little
community legal centres for training. So that's why we are very grateful for any opportunity that's provided by Legal Aid, any of the organisations, our peak body, Community Legal Centres Queensland, that runs webinars. So anything like that comes our way, we have to take advantage of, because we certainly don't have the resources to be able to pay to attend a day seminar or anything like that.
Okay.
Yeah.
Well, it isn't just the cost, it's also the fact that you've got people offline that are attending the programs. That's the other issue.
Yes.
Trauma-informed is so critical. And how it comes down, especially when you have court trials or bench trials rather than jury trials, is if the judge isn't trained in terms of trauma-informed, then the judge might be finding that the witness isn't telling the truth because of an expectation of how the witness is supposed to present him or herself as a result of this experience. And what do you mean you don't remember? Well, this is why you need to understand strangulation really well, because it's not uncommon during non-fatal strangulation where the person becomes unconscious, where there's going to be gaps in their memory with respect to what occurred. And a non-informed trier of fact might say, gee, if I were non-fatally strangled and almost died, I'd be remembering some of this stuff. Well, the simple fact is you wouldn't. If you're trained and if you're informed. So everyone needs to understand this, the lawyers. And the other thing that's of a concern for me, and this is in the States, is that a lot of times the public defenders don't know as much as the prosecutors with respect to a knowledge base. The men have a tendency to want to go to trial. Women have a tendency to want to plead their cases more quickly because they want to go home and be with their children. And so, the public defender gets the best offer they can get, and the women usually take it, and the men sometimes take it or whatever. And I've tried explaining, do you understand why women take the offer so quickly? It's because they need to get out of custody, they need to get home. And you try and inform them of these things, and they basically tell you to mind your own business.
So we're moving down a path here in Queensland of specialisation in relation to domestic and family violence in the court system anyway. What's your view on that, or is this something that really everybody should be able to manage?
All right, let me make this again based upon my American experience. I want to be clear that I'm not disparaging a country where I'm a visitor and where I don't know. I believe in specialization. The caveat to that is assuming that the person is properly trained and assuming that the person wants to be there. There is nothing worse than appearing in front of a judge who doesn't know what he or she is doing and doesn't want to be there. And there are plenty of judges that don't want to do domestic violence because if it's so bad, why does she stay? They view it as a hardship assignment. As a matter of fact, in my jurisdiction, you'll have some people that will bid for domestic violence hoping to avoid doing a family assignment afterwards. If the supervising judge, chief judge calls up and says, hey, it's your time to go to family. Whoa, time out. I just did domestic violence. You can't send me there. I just finished this other horrible assignment. So that's horrible. It's better that you don't have anything that's specialized unless the people are trained and they want to be there. Now, most people want to do a drug treatment court assignment because we call it in the States, it's called clap court, hug court. Everyone's happy. People are clean and sober, they get back to their families, and it's great. But you don't have hugging and clapping in domestic violence court because the bottom line is someone did something very seriously wrong. I'm not saying you put them down. But you don't minimize it by saying, hip hip hooray, you've completed the program, because that's just the beginning. And if you don't make a lifetime commitment to being controlling-free and violence-free, you're going to violate. You're going to reoffend.
And what about risk assessment? Louise, how does risk assessment come into your practice in the CLC context and in your broader network of relationships?
In the neighbourhood centres and all of our organisation, we do have different services have different risk assessment tools, which they all make use of.
Is that a problem, that they're all different, or are they not different enough?
No, I think they have to be tailored a little bit to the service. For example, our family support program, where our service providers go out into families, have to have a risk assessment that is tailored towards meeting both the worker and the client's safety concerns. So although it is generic in some regards, it has to be specific according to the service. So we do have those risk assessment that is ongoing, initial and ongoing, and certainly at the neighbourhood centres, anybody who walks in the door, that's the first thing that's done. So at the community legal centre itself, I think it's also an ongoing thing, and something that you mentioned, Judge, with regard to trauma-informed training just flagged me, and I thought I might add here that I think that one of the real weakest areas that we find insofar as seeing people is the preparation of court paperwork, affidavits and things like that. I know the first time that I experienced trying to prepare an affidavit for a client who was traumatised and who had an absolute brain fog and could not remember anything or give a sequential breakdown of what happened when. Nobody ever told me that was going to happen or what to expect, and I was just faced with it for the first time, realising that this was happening. Stopped consultation, referred for counselling, but there's no training around that. Even if with some counselling, with some support, and as empowering as it can be for somebody to deal with it, they still have to come back at the end of the day, and you need the facts and how to get those facts. Very time consuming. We have an hour appointment. There's no way that in an hour you can get even half the information that you need. So you end up sitting there actually having to set aside a day at a community legal service which is under-resourced and not specialist to be able to do that. But we do that because we can see the very person sitting in front of us who needs that help, and there is nobody else to help. And often legal aid, if they don't fall under legal aid, there is a fine line between getting legal aid and not getting legal aid, and a lot of the clients only just don't get legal aid, only just, and then they'll never be able to afford a private solicitor, so there is nobody else to go to for the legal help, so they do come to us. So we feel a great sense of responsibility towards making sure that we can give as much support as possible, but learn as we go.
Well, the other problem is that you have people that do this work, not just the police and probation, but also the court, and sometimes the prosecutors and defense attorneys are suffering from PTSD as a result of this. They don't realize it. They're suffering from burnout, and as a result, they do a lousy job because they just shut down. So that's another part of the problem, where you need to be really engaged in self-treatment. In terms of, self-care, thank you. How are you going to protect yourself? And I found, not so much from some of the domestic violence, but I was doing, toward the end of my career, a lot of molest cases. And some of my colleagues were refusing to do them. And the boss came to me, he says, look, I really need your help. And I was doing back-to-back molests. And they were 10, 11, 12-year-old little girls. And it's like, this stuff really eats you alive. And if you're not careful, you start shutting down, in which case you're not doing anyone a favor.
Can I get you to talk about risk assessment too, from the bench perspective?
Yeah.
So do you trust the risk assessments you're presented with, and yet there's red flags that people don't seem to be picking up? What do you do about that?
Well, as I like to remind the experts, every division has its experts. In family court, you have child court evaluators. In probate court, you have probate investigators. And in criminal court, you have probation officers. Experts make recommendations, judges make orders. too many judges are more than happy, and I'm not saying it's inappropriate. Probably most of the time you're going to follow the experts' recommendations with minor tweaking. But you have to be, I think, in a situation where if your gut tells you this isn't right, you need to do what you think is right. And everyone and his brother can be recommending that this person be released, and if it doesn't make sense to you, then you got to detain them or keep them detained. Risk assessment, judges really aren't trained on risk assessment. I mean, again, speaking in the United States. They're taught basically to trust the experts and to trust those people that are filling out the forms. Well, if there's a gun in the house, the guy's talking about suicide or talking about killing his partner, why would you release someone like that? And why would you allow that person to have unsupervised visits? Because a person like that is going to kill the partner, kill the children because he's going to kill himself, and the philosophy there is, they're going to become orphans, they're better off being dead. And, we needed something like that, and then the system starts to examine itself, then there's a commission, and then the end result is back to business as usual.
Can I ask too about, you mentioned, Louise, that often people will come in and it'll be in the course of the conversation that you'll realise that this is family violence. Do you name that for people, and how does that go, or do you make a call on that, or what do you do with that information?
I think we just really take it on a personal matter by matter. We do have brochures, because what I've found personally quite useful is sometimes people saying to themselves and vocalising it that, well, this is not really domestic violence, but this form of control. I'm not really experiencing that. And having it in writing with a list of these are the types of domestic violence, and actually giving it to them and saying, have a look at that and think about that. And maybe they're not ready to accept it immediately, but just knowing that the type of experience that you're experiencing does fall under what would be described as domestic violence, and giving that to people. And maybe they don't call it on that occasion, but I think the good thing about being at a community legal centre is that we're not there to take control of the situation, and people are very fearful. They want to build up that trust. They're worried about the fact that they inform a solicitor, and that means the matter's going to run away with them. And they're very, very fearful of that. So a lot of our time is spent reassuring people that it's entirely their call, and that the progression of the matter will happen or not happen when they're ready. And a lot of people are ready. A lot of people just want information, educating themselves. So it is about naming it, if appropriate at the time. We have to use our own discretion about it. And then...
and is this for perpetrators as well, or people that are...
for perpetrators as well. Perpetrators, usually the first time we see them is because they've been served. So no, I don't think anybody's ever had somebody coming in and saying, I'm thinking I'm committing acts of domestic violence. It's usually the opposite. It's usually I've been served for some paperwork, and varying responses to that. Sometimes explaining, for example, one that comes to mind is something about, breaking down my door. Well, it's my door. If I want to break it down, I will. And explaining to them that in the context that's not actually behaviour that should be going ahead. So sometimes calling that out and explaining them again. This is what domestic violence is. Explaining the law in plain English, and if this behaviour falls under the parameters of what domestic violence would be, then you need to consider whether you should be consenting without admission or contesting. So it's about discussing options, and often it's not that first consultation where people will make a decision, because often the experience that we have is people will say, I didn't do it. And it's sometimes about hearing what the law says, hearing how their behaviour matches what the legal system says, and then coming back again and considering it and deciding what to do then.
So before we break for questions, Judge, did you have anything to say about that point? Is there a role for judges to call behaviour?
I think. Oh, absolutely. What I have said to men is that, do you understand that your partner is afraid of you? Do you understand that your kids are afraid of you? And that's why they don't want to visit with you, is they're scared. They've seen you hit their mother, and that hurts. And sometimes there's an acknowledgement, sometimes there isn't. The other thing I think is sometimes helpful with victims is to use the power and control wheel and to go through the various cycles and to explain and to analogize what they're experiencing on the power and control wheel. Sometimes I saw a police officer do that, and I thought it was very effective in terms of how he, when he goes on a call and he wants them to take action and they're reluctant to take it, and he takes out the power and control wheel, explains that you're experiencing domestic violence, because they're in denial a lot of times. And by using that as a tool, as an example in terms of what's going on, he has found it helpful. And I think that's an approach that might work with the right person.
Okay. Are there questions from anyone? I'm taking all these notes from Minter Ellison about appeals and training, but yes? Terry, isn't it? Yeah, Terry, hi.
There's a direct intersection between child protection and domestic violence. We do have magistrates that are specifically allocated in many of the courts to deal with the domestic violence matters, and we have magistrates that are specifically set aside to do child protection issues, and they are supposed to be doing training to upskill themselves on this. There seems to be quite a void between the issue, the matters of child protection and domestic violence, and they go hand in hand. And the problem being it's not recognised sufficiently, particularly by the players involved, that what they're appearing in front of a magistrate for family domestic violence is going to be something that is going to be not to their interest with child protection. So what is happening is a lot of the victims of domestic violence are actually withdrawing their applications for fear that they're going to have their children taken. And that happens to be a common first response to what has happened. There needs to be a far better approach to what's going on.
Can you talk about the story of that in the US? I do think that's a problem here as well.
Oh, it's a huge problem, and it's not limited to the United States or Australia or any place else. Unfortunately, there's a difference between applying for a protection order, restraining order, which, if you're the moving party, you can adjourn it, dismiss it. Once you get care involved, protection involved, you're not the one that's the petitioner, the state's the petitioner. And once that train gets going, it's really hard to stop it. What we did in my community, one of 58 counties in the state of California, is a community that got together, and they had discussions with the social workers that are involved in this area, and to try and work something out where the victims didn't feel that they were being placed in a situation where they had to choose between their children and their partner, in terms of getting them reimbursed so that they were able to do what needed to be done to keep their children safe, versus what is going on, and also get resources with the partner in terms of getting him in domestic violence classes and things of that nature. It really depends in terms of whether that works or not, because the bottom line is children have to be protected. Sometimes it is a situation where, if the child is going, if the mother is going to stay with the partner, assuming that she's the one who's taking care, and if she is regularly experiencing domestic violence, then there will be a removal. It is the most difficult friction in terms of systems, and it's one that is always in flux, and one where advocates that are helping victims are always trying to negotiate different kinds of resolutions so that doesn't happen. And we, as in terms of a society, try very hard not to remove children, because we know that removing children has an outcome down the road that's not good in and of itself. So there's a friction between the outcome of removing a child to begin with, and then there's the outcome if we don't remove the child. So it's not easy.
Louise, how about you? If you've got a woman coming to you saying she's thinking about leaving, this is what's going on at home, and you think that sounds like a difficult place for a child to be, there's, what's your advice? How do you manage that situation?
Yeah, well, while we were mentioning what you're mentioning, a thought occurred to me that we do also provide the Child Protection Duty Lawyer service at the Pine Rivers Magistrates Court, and although I don't personally do it, we have had experience where we've actually varied protection orders where a child had been removed by child safety, and then even with a protection order in place, and then varied it to increase protection for the child, and then child safety withdrew. But each matter is so much, very much an independent, individual response to each matter. So seeing what happens at the domestic violence court and seeing what happens at the child protection court and seeing what happens in our consultations in our offices, it's how do we connect all of those things, and it is a struggle daily to try and get the right balance there.
Any other questions? Yep, Ross.
Louise, I'm interested in your thoughts about if you could wave a magic wand in terms of a community legal centre that's running a generalist practice that has a whole lot of stuff walking through your door that does also include domestic violence, but not exclusively. Do you have a sense of what the best practice model is for a generalist service in dealing with domestic violence that also allows you to still run that general practice into, I know money's always an end game here, but in terms of, if there was a particular model that you think would be a much more responsive or adequate model?
Well, I think we've been thinking about that kind of question and trying to adapt our workflow to try and fit that in, because most of the time if you have a CLC that is a specialist service, that's all they do. But as a generalist service, with almost a quarter of our work now being domestic violence related, we've just been throwing it into the mix, and I think that at the moment what I'm tending to think might be really beneficial is if you would be able to have one solicitor who would actually be available all the time to be able to do domestic violence work within a generalist service. And but I don't know if that's the right model, and I don't know if that would actually work, but it's about the time and the resources available, because other specialist areas we can refer people on, but we know that, as I said, if we refer people on, there may be a lost opportunity. So we need to be able to help people, and that's perhaps what we at the moment just manage daily. But perhaps if we had a solicitor that would be able to, or at least one who would just be there dedicated to be able to help, and a dedicated support person surrounded by all the other support that's available. But from a purely legal perspective, to have a dedicated, well-trained, trauma-informed solicitor who is able to do that work and support the other solicitors in the team would be great.
Mm-hmm. Yep.
My question is to the panel as a whole. Are there any responses from a legal system, from the judiciary, that you're seeing that really stand out as being particularly effective, or that really have been a positive impact in your mind?
Well, I think so. In terms of therapeutic jurisprudence principles, you have to talk to people with respect. You have to also be encouraging while acknowledging what the harm is. You have to encourage them that there is the possibility of remaining violence-free, of being a good father, of participating in the rearing of children. You have to give that hope, but you also have to, let them know that there will be accountability in the event that there's shortcomings that put people at risk or reoffending. So it's a fine line between, if the drug court model, which is a medical model, expects that people are going to reoffend in the sense of using substances. That's a completely different model with respect to domestic violence. There is no free reoffending or free slipping or passing. I mean, there's strict accountability in that model. So I think that there does need to be a lot of encouragement. A lot of these people are damaged, and I don't mean that in a disparaging way. I mean, some people have just grown up in horrible homes. That doesn't excuse the violence, but it provides an understanding, and you need to encourage I'm a big believer of encouraging, and I do believe that people can change. I just believe it's very hard to.
Louise, have you seen some good practices at Pine Rivers
I
Magistrates
could really
Court?
talk about the Domestic and Family Violence Duty Lawyer Service because that's what we do. But what is encouraging to me is how magistrates are referring people who perhaps don't put their name on the list at the start of the day to see the Duty Lawyer Service, who pick up perhaps the self-represented applicant who has referred to a choking incident and just thrown it in the middle of somewhere. And magistrates seem to be picking up and setting matters aside and saying to the person, go and see the duty lawyer. So I think that the duty lawyer service, certainly in our experience and availability of it to be able to support people, and the way that the magistrates encourage people to access the legal advice is really great.
Yeah. Some of the things I've heard about too are judges actually doing their job, actually seeing themselves as decision makers. So when there's subpoenas or adjournment applications or consent orders, they're not rubber stamping them, they're actually thinking through whether this is the right outcome in the circumstances. And I think that's really important, that we don't look for we want our judges to actually think things through and make a decision based on the material before them, not just rubber stamp any of these things.
Absolutely.
So we've had a lot of problems, and some of you I know have had this issue with wide-ranging subpoenas for a whole mental health record, for example, which may not be justifiable, for example.
No, you raise a very important point. In the criminal arena, once the police or the prosecutor, depending upon, has filed a criminal complaint or information, whatever your document is called in your system, then if they want to amend it or withdraw it or whatever, it needs permission of the court. And too often in the States, people are happy just to have it off the docket. Oh, you want to dismiss it?
Great.
That's fine, great. That's one less that I have to try. Whereas the judge should be saying, well, why? You have to be careful because you don't want to give the impression that you're prejudiced toward the prosecution, but you have a responsibility saying, why do you think this case is improvable? It's not a question of the judge saying, I think this case can be proven. It's a question of the judge saying, this is a case that the public is entitled to hear. Whether it be up or whether it be down at the end, this is a case that ought to be heard. And it isn't just that. I mean, the other thing in family court, where the volume is just staggering, you're being given stipulations. Now, a judge doesn't have to accept the stipulation, but it's really hard when you don't know all the discussion that took place between the lawyers to say, I'm not comfortable with this stipulation. I mean, in most cases, they're not even read. They're just presented to the court, and the court signs them. And that, in my view, is asking for trouble, because sometimes the lawyers aren't doing their job.
We are actually at time. I think there's a vote of thanks from somebody.
On behalf of everyone here today, and particularly from a student perspective, I'd just like to thank Ellison for hosting this really important event, and for CLC's Queensland as well, and then particularly to our speakers today. Louise, your really practical insights from the front line were just so insightful to listen to, particularly from a student perspective going into practice. And then Judge Hyman, particularly your insights from a judicial perspective and the comparison with the US was really interesting. And of course, Professor Douglas for taking the panel today. So if you could all join me in thanking our panellists.